I'll be just like this.
Yeah. Hello, good night to the listeners, the viewers of Legalize. Welcome. On 16 October, Justice Ralston Glasgow of the Grenada High Court, in a historic judgment, declared the punishment of flogging to be unconstitutional and therefore unlawful. Flogging had been a lawful punishment in Grenada since the days of slavery. It remained on the books despite the abolition of slavery 190 years ago. A few days prior to that historic judgment, the British Prime Minister, Sir Keir Starmer, ruled out the payment of reparations by Britain for the horrors inflicted by the system of slavery. He simply said, "We do not pay reparations." He also refused to have the issue of reparations on the agenda for the upcoming Commonwealth Conference. Shortly thereafter, the leader of the opposition in Britain, a lady of African descent, also ruled out payment of reparations. The result of the elections in the US is also considered in some quarters as a setback for the reparations movement. Tonight, we have with us Attorney at Law Jerry Edwin, the attorney who led the charge to outlaw flogging, and Jomo Thomas, another attorney at law from St. Vincent, and among other things, former chairman of the St. Vincent Reparations Committee. Before I introduce and ask for comments from them, I just want to recognize the sponsors of this program: Gel Professional Solutions, Gem FM carrying this program in Canada, and Grenada Technical and Allied Workers Union.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Good night, Jerry. Good night, Jomo.
Good night, brother. Good night. Good night, brother Layne. Good night, brother Mr. Speaker, former Speaker, brother Thomas. Good night to you.
Hey, how are you, Jerry? Good to see you again.
Fine, thank you, my friend. Good to see you.
Viewers, we may have little issues with the internet. I think it has to do maybe with the traffic on the internet and also with the weather. So just bear with us, please. We will do whatever we can, whatever is within our control to deliver this program as best as possible. So, Jerry, maybe we hear from you first.
Good night to everyone. Good night to everyone who is listening to us in Canada, on the internet. I hope everyone and their family as well. I'll begin by saying that when I first discussed this about what we could do as lawyers to abolish this treatment, this punishment, it was in 2017. Wow, 7 years ago. And, I was reflecting before we came on the program. I mean, it was almost your reaction, Brother Layne, was immediate, almost as though you had been thinking about it long before me. It was always in the top of the list of your things to do in terms of reforming the law in Grenada, weeding out those laws that belong to a different era, thinking about those laws that ought to be gone in a young, developing democracy that had been held down by slavery laws, dominated by countries and systems that really were designed to keep them down. I mean, I was just thinking how easily you responded by saying, yes, let's go ahead, that this is a law that has no place in a modern society. And how quickly thereafter you said, let us find someone, find a litigant. And that actually set me to work. And we discovered that there was a young man in Grenville who had been flogged in the magistrate's court. What happened is he had apparently stolen some vegetables, and the magistrate decided right away to send him to be flogged. So we found the first litigant, and I think a couple of years afterwards, after we had actually filed the case in 2018, you said we should also tackle the criminal code. And we found a person who had been flogged for robbery with violence. And then it's like you rolled out the machine, brother, because the pleadings that you came out with and the research that you conducted, I felt like I was your clerk, and we just quickly, I mean, I don't know how to say this, and I really, frankly, don't care about your modesty this evening, Brother Ewart. But I think without you driving this case, drafting the pleadings, doing the extensive research, this case would not have gotten very far. I would have still been struggling with it. And so that's where I'd like to begin, by the vision that you shared, that this law, this barbaric, anti-constitutional law, should be struck from our books, and the yeoman effort, really the incredible effort you put in driving this case to where it is today, after a judge had looked at it, and I must say adopted virtually every single argument that you put in the papers.
Okay, I must say I'm quite flattered, and I'm not being humble. I'm not being exhibiting any false humility, but I must recognize your own effort in that, Jerry, as the attorney who really drove this thing. I guess your experience coming out of the 70s, your experience in America. But we must also recognize the contribution of Robert Ferguson King's Counsel, who was the advocate that before the court. And there was
on that note, let me, if you may allow me, Brother Ewart, I think that Justice Glasgow, in his decision, he put a finger on the skill of Ruggles' argument. And Mr. Ferguson, as he said, deftly and skillfully removed the bar to getting rid of flogging. It was the main argument by the crown, by the government, that really these punishments were saved, and there was this coffin called a savings clause that's built into our constitution, Brother Jomo. And throughout the Caribbean, the argument was that there is a savings clause, therefore the court should not interfere with changing these forms of punishment that predated the Constitution. And Brother Ruggles he skillfully said, yes, it is saved, but there's a difference between a general clause and a specific clause. And we had to examine all of the laws because of what the savings clause did. And at first we were thinking of going to a very esteemed, highly recognized UK lawyer whose firm has assisted many litigants in striking down laws. And Edward Fitzgerald KC is well known in this jurisdiction for his commitment in assisting litigants in getting rid of some of these laws. I thought, no knock on the tremendous commitment and the assistance that we had received from Ed Fitzgerald and his firm. I thought the nature of this beast, the nature of this thing, the fact that we should look inside of ourselves, and I may have a critique on reparations that may dovetail with this, Brother Jomo, that no better person would be suited than Ruggles Ferguson to carry the argument before the court.
Well,
Yes, Brother Jomo.
there are two very important points you made, Jerry. One, anyone who knows Joseph Ewart Layne would know that he is a master of the craft. And it's rather unfortunate that, and it's a loss, I think, not only to him personally, but certainly to practitioners and the jurisprudence across the region, that his application to be admitted to the rolls to practice law in Grenada and by extension in our region was denied. But as you clearly pointed out, he has continued to make his contribution and continues to make an outstanding contribution to the ways in which we frame and bring cases before the court. I can tell you that he has helped with a number of matters in my own personal efforts here in St. Vincent and the Grenadines. And most importantly, he was one of the lawyers, in addition to Cara Shillingford and Zita Barnwell, who helped to bring the vaccine mandate case. And many of the grounds that we argued in that case, Justice Henry agreed with them and came back with a most forceful judgment, finding that the vaccine mandate, as was put forward in St. Vincent and the Grenadines, was unlawful, illegal, unconstitutional, procedurally improper, and disproportionate. So anyone who knows him will know the kind of commitment that he brings to an understanding of the law. But equally important is the work and your lauding of KC Ruggles Ferguson, because you go through the cases up and down the Caribbean and he has made a mark. And it is not by choice that, and the humility and humble nature of these two brothers, you had to take Ruggles kicking and screaming to get him to do the necessary papers that allow us to call him King's Counsel today. But certainly, both of these gentlemen have served Grenada well, and by extension, Ruggles was also instrumental in a case over here, very important case, which was popularly called a teacher's case, in which the government failed to honor a collective bargaining agreement it made back in 2005 with the teachers union, in which there was an article in that agreement, Article 16, which allowed teachers who had been working in the system for more than 3 years to contest elections, and if they failed to win the favor of the people in the constituency in which they ran, they would be allowed to come back into the teaching profession. Well, the government signed the agreement. Prime Minister Gonzalez was on witness to that agreement. And when the teachers ran and lost, the government refused to allow them and said that the signing of the contract, the agreement, was only aspirational. Well, we took that to court, Ruggles. Well, when we argued at the court, at the first instance, the judge said that the agreement the claim was hopeless. And then we appealed, and Ruggles argued in the Court of Appeal, and Justice Davison Baptiste brought back a brilliant decision in which he ruled in favor. So these two men, Ruggles Ferguson and Joseph Ewart Layne, have made their mark not only in Grenada, but certainly here in St. Vincent. And I'm always honored and proud to be part of anything that they're involved with.
Yes, yes. I share that. I share that as well.
I just want to also, in terms of this matter, point out that the name is just eluded me now, but there's a lady in England who, King's Counsel, who really very early came on board with this matter to assist us, and in fact was able to obtain an opinion from a leading law firm in England, which really confirmed the line and the line of argument, Jerry, that we were taking, you know. So that was, if you want to say, that confirmation assisted. And of course, you mentioned Edward Fitzgerald.
Yes.
And there was Simon Newhead's lawyers, in particular, Parviz Jabba.
Yes.
Because they have done these type of matters in Africa and in other Caribbean countries.
Yeah.
I think this particular matter, in terms of success, was very important, because in fact there was a previous matter taken to the Privy Council from out of Bahamas, in which the punishment of flogging was challenged, and the Privy Council was split 3-2. They upheld it. They said it was lawful, but two of the Privy Councillors dissented. However, they did not take the argument that was successful in this case here. They took the arguments, but they didn't take the argument here. But just to go back a bit, Jerry, because last week, the president of the CCJ, Justice Adrian Saunders, was on, and he made mention to this savings clause, on these savings clauses, which are really a plague on Caribbean jurisprudence. I don't know if anyone could just explain, or I could also venture, you know, but if anyone could explain what these saving clauses really do in terms of saving colonial era laws from challenge.
Well, essentially, what has happened with when Caribbean countries, well, former colonial countries in the British Commonwealth, when they became independent, there was this clause, which is popularly known as the saving clause, which essentially saved all of the laws that were made under the colonial administration. And it's as if countries were not really starting from scratch after independence. They were building on those set of laws. So if I understood Justice Saunders clearly when he was on last week, and I have also followed many of the decisions, I think that there are two decisions which Justice, what's his name again? The justice who did this one, who did the flogging case?
Glasgow.
Glasgow. He cited to two of those cases from the CCJ. The Chandler case out of Trinidad, in which the Privy Council said that it would have to be the legislature who can move against to remove the savings clause. And there was that long decision in there that even after the Republican Constitution in Trinidad in 1976, they allowed the savings clause to stay. And as a consequence, they ruled that the death penalty would remain, even though there was an assault on the issue of the death penalty having to do with it being violative of the fundamental rights and freedoms which were enshrined in the Constitution. But the CCJ in the McEwan case dealt with the issue of the savings clause, and I think that's where the CCJ is making a part in creating its own jurisprudence, Caribbean jurisprudence, where it argues essentially that where the saving clause comes into in sharp contradiction with the fundamental rights and freedoms of the people, which are enshrined in the constitutions, that that has to give way to the fundamental rights and freedoms of litigants, of citizens. And I think that's the direction which justice went here in making this ruling, having to do with, well, not so much because this was more decided on the question of discrimination and so on and so forth. But I think that's where the deviation is now taking place. Whether the saving clause are sacrosanct and can only be removed by legislative action, or if a court looking at the challenge can come to the conclusion that the fundamental rights and freedoms which are enshrined in the Constitution are being violated by the particular provision that is being challenged, and that the CCJ is saying, yes, you can move in that direction, step away from the savings clause and to find the act unconstitutional. And that's what they did in the McEwan case from Guyana.
You know, I thought that in reading, Justice Glasgow relied on that case from the CCJ, a couple of them, one from Barbados. Byron sounds like a real revolutionary, speaking of these colonial era laws having to give way to the aspirations of people who have just come into freedom. If one reads that jurisprudence, I mean, it is the language almost should have been a mandate for these political leaders who were the ones that led these countries out to where we are now. But what struck me though, Joe, is when we first went in 2018 or a little while after that, we went to the former prime minister and we thought this would have been an easy sell because all of us would agree these laws are inhuman, degrading, they belong in another era. And in spite of the savings clauses, Parliament is still empowered to pass a new law. We thought perhaps it couldn't be that Black leaders like us would agree to beat other Black citizens in a fashion and a form of punishment that belonged in an era when we were oppressed. And so when the former prime minister threw his hand up in the air, I thought to myself, well, the struggle continued. And then
but Jerry, there's another point to that, because I don't think the flogging is on the books here in St. Vincent, but it has not been executed in a long time. But you would be amazed, particularly on issues of pre-deal larceny and some other crimes, that there's a sentiment in the society which speaks to the utility of flogging other human beings. Because our society is very aggressive in the ways in which we want to respond. And this is why sometimes I don't know if people have a clear understanding that when they support like flogging for children or flogging, in this case, for prisoners, people who would have contravened the law, that they are setting up a mental construct which allows for physical responses or aggressive, forceful responses, another aspect of societal affairs. But there's some support, and you may find significant support depending on what the issue is for flogging.
I think it actually crosses. I think it crosses all age demographics, all aspects of our society. So in 2022, when we got these young politicians in Grenada, I was buoyed. I thought, wow, finally, young people are going to say it's time to get rid of this as well, because they are more enlightened and progressive, evolved, but same result. The new elected officials literally did the same as the old elected officials and threw their hand up in the air as if to say, well, what can we do? But I think they were driven. The politicians are thinking that they have to pander
exactly
to this element
their
in the
constituency.
society. Yes, or they will be. And Jomo, I think that it's like domestic violence. You talk about this acceptance of physical violence bleeding over to other parts of the society and becoming normative and normalized. I think, for example, of domestic violence, where a woman is struck by her husband. She calls the police after the beating. And when the police arrive, one of the questions invariably they ask the lady is, what did you do? What happened? What did you, what caused them to do? What caused them to hit you? We have come to accept beating. If you think of the pre-deal larceny law, I think this is how bad it is, Jomo. So we had flogging on the books for women. I think it ended in 1850s. And since 1895, past
1824, prior to the abolition of slavery.
Yet you have a pre-deal larceny law enacted in 1990, where the punishment of flogging is deeply rationalized by, I would say, evolved men and women. In this modern parliament, you have intellectuals. Dr. Alexis, I'm going to say, Dr. Alexis, the preeminent constitutional scholar in the region, and at the time he was the Attorney General of Grenada, approved of the law for beating people in 1990. So this cloud around our brains is perhaps more entrenched and than we know, because the political class, regardless of the age and generation, was unable to see past violence as a form of acceptable punishment.
Yeah. I think there's really an issue, Jerry, as you use the word pander to the electorate, or maybe I may use a different language. They basically don't want to spend political capital on these issues, because, as Jomo says, but Jomo, I can tell you the use of flogging has been widespread in Grenada. I mean, people have been getting flogging for traffic offenses and things. So even when the law does not allow it, and there's no outcry in the society, there was no outcry even among lawyers regarding that. Yeah, I know Ruggles did one or two cases on that, but it was really when Jerry took up this case that you had some momentum behind that in terms of getting that punishment removed. So
well, actually, Joe, I think you had, when we filed the case, you had asked for an injunction.
Yes,
and
the
court actually granted the injunction in 2018.
Yes.
So since 2018,
there has been
no flogging in Grenada, awaiting the decision of Justice Glasgow. But even colloquially, you'd hear people speak of beat him, man. The thing has crept into our local parlance, our expectation. It's been normalized that violence by the state, and I would argue violence generally, is justified as a form of punishment or even just to resolve dispute. I don't know. I don't know that we do not need, as a people, some kind of psychiatric therapy to get past this.
Well, it's part of the slave syndrome, Jerry. That it has ingrained in us. And I normally say here, when I make certain commentaries, that post-colonial St. Vincent is not post-colonial. And I think by extension, we can say post-colonial Caribbean is not post-colonial, because a lot of the thinking is still very Eurocentric. And if our thinking is Eurocentric, and we are coming from a position that we are the children of the enslaved or the formerly enslaved, but precisely because mental enslavement is still a major issue, a lot of the discourse which we have is tainted by that mental construct, which allow us to rationalize, which allow us. There was a part in the decision where Justice Glasgow talked about the part of the reasons for these decisions on flogging. I guess it came either from I can't remember if it was somebody writing in a book. He was saying these are not the children of the industrialists and the bankers and so on and so forth. These are the people from the lower echelons of society, which everybody either don't care for or can easily demonstrate disdain and disregard. So I think that explains to why even in 1990 or still in St. Vincent, it's still on the books to have flogging.
I think that's it. It's the idea that there are classes, there are categories of people in our society that we can throw away, disregard, whose voices we cannot attend to. I think this is the major service for which this decision was intended. I think Justice Glasgow literally conducted a rights clinic through this jurisprudence when he went through courts in Tonga, Namibia, India, you name it. He went all the way. It was such a thorough look at all of the issues, not just the savings clause. And on the savings clause, the idea that, and I was surprised because I hadn't read Justice Byron's decision on the death penalty case in Barbados, Brother Ewart. And I was surprised to see how clear the jurisprudence is on these issues and how far behind our societies are in catching up to the jurisprudence. So it seems as though we want to build a new society, but we are trying to still build it on the old platform of a post-colonial society with these old laws. And I don't see how we can build a new society in these islands by doing that, Jomo.
Yes. I just want us to pay a little more attention and speak a bit more on the savings clause, because somebody say, why does savings clause still, in my view, seem to be like a piece of rope around our neck? And I think, Jomo, you started to explain the situation with this savings clause. But there is a distinction which I think we should just deal with, that Grenada was the first of the Caribbean countries that obtained independence from Britain that did not have in the Constitution a general savings clause. What happened is that the constitutions of Jamaica, Trinidad, Barbados, Guyana, Bahamas, they all had a clause which says that, listen, we give you independence, yes, the Constitution is supreme, yes, your parliament cannot pass any law that is inconsistent with this Constitution we are giving you. However, if there is any law from the colonial era that is inconsistent with the Constitution, notwithstanding that inconsistency, it is still lawful. In other words, you cannot, the parliament could change it, but the courts cannot change it. Obviously, understanding, Jomo, that politicians ain't going to touch laws on the death penalty. Politicians ain't going to touch no law on flogging. And these are the kind of laws. No politician going to touch that. And our experience has demonstrated that. So that's why in Jamaica, Trinidad, and so they stuck with that. But in Grenada, what happened is that we have a clause which gives the courts the authority to modify the laws, to bring them into conformity with the Constitution. Ultimately, that is what Justice Glasgow did. So Grenada, St. Vincent, St. Lucia, Dominica, our constitutions all have this clause. However, and that's where our case, the Grenada case came in, Jerry. There is a clause, while the Constitution says that no one should be subjected to cruel, inhumane punishment, there is a specific clause in that section which applies to nearly all the constitutions in these smaller islands, which says that any description of punishment that was lawful prior to coming into existence of the Constitution shall not be declared or held to be unlawful simply because or only because it is inhumane. So, for example, everybody agrees that flogging is inhumane. Everyone agrees with that.
Yeah.
The government side agreed with that. But their point was that the court cannot declare it unconstitutional because there is this savings clause that says that the court cannot do that. Therefore, they must go to the parliament to do that. And of course, we know no parliament is doing that.
I like the way Justice Glasgow dealt with that. In terms of what he said is, then you've made a lie to the whole issue of judicial review. You are saying that if we were to accept that, these savings clause are like a permanent seal on these pre-independence laws. I think that the way he dealt with it was and again, he paid great reliance on the decision by Justice Saunders. I thought it was just the way he tore this argument apart by saying, here you have actually quoted Professor McIntosh, who said you have this this common ordinary legislation that is going to be like a chain in the foot of freedom. That is, you can't say that we have fundamental rights, fundamental freedoms, if there's a piece of legislation that says you have to save the old law that denies those freedoms. I thought by saying the courts, it is the court's role to take a second look at all laws for their constitutional nature. I think that is what drove the sword to this savings clause, because he says the savings clause, the second look at the savings clause applies whether it's general or specific. I'm wondering whether his view on it can assist the first islands who got their independence to relook the idea that savings clause prevents them from removing, for example, in Trinidad and Jamaica, the death penalty from their books. What are your thoughts on that, Joe?
Well, I think that that's the point that the CCJ took up in the Norvais case, where they addressed the issue of the savings clause and concluded that where the savings clause is in fierce competition and contradiction with the fundamental rights and freedoms of the people, that the savings clause must fall away. So that's the jurisprudence which I think I first saw it in Norvais, and then they reiterated it in the McEwen case that came out of Guyana. So, even after, well, certainly after the Norvais case, the Privy Council came back in the Chandler's case out of Trinidad and argued that essentially the savings clause is sacrosanct, and you couldn't move it. Well, the court couldn't move it in the way in which the litigants had argued there. The position, as they argued in Chandler's case, was that in 1976, when the Trinidadians dealt with the Republican Constitution, they did not even make an attempt to touch that. So, but I think that's the way to go. I mean, you can say a right is a fundamental right and freedom of people, and then argue that there's a block. You can't get through that door, because it's like saying that you have a right without a remedy.
Yes.
Yes. So someone is saying the Savings Clause in Section 5 is not in conflict with Section 13 of the Grenada Constitution. That's the point I wanted to address, that this case was not determined on the basis of Section 5, because the court did recognize that is a barrier, the specific Savings Clause. However, the jurisprudence coming out of the Caribbean cases, and even out of the English cases also, is that a Savings Clause must be strictly construed, narrowly construed.
Very narrow, very narrowly construed, very narrow. It's like, Joe, if I can say this, and I was struck, Jomo, by how in the US, the Supreme Court has this 3 tests: rationality, intermediate scrutiny, and strict scrutiny. I was amazed how, I mean, I don't know constitutional jurisprudence like you brothers do, but I was struck how the Caribbean jurisprudence has been able to synthesize these 3 concepts of rationality, proportionality, and I was struck how that, well, not so much proportionality, but the idea that you could employ these tools to reform our law. I had no idea that these judges or these courts had gone so far forward that the 3 arms of government, the legislative, the executive, and the judiciary, how in this relay the courts were so far ahead of the executive, Joe. The courts seem to be so very far down the line to helping our people evolve and to realize their true potential. It seems like we're held back in our aspirations by the parliament. I mean, I'm maybe generalizing.
Maybe it's the rope that was handed to us together with the Constitution, as somebody said there. You give me a Constitution, but then you say that all the laws from the colonial era, they remain good laws. You can't interfere in them. That's in the case of Jamaica and Barbados. And so you can interfere in them, but the parliament has to do so. The courts cannot make any declaration and say that these laws violate the fundamental rights that the Constitution now provides for. And in the case of Grenada here, what we had was, as I said, the specific clause. But the point is, just to go back again to, if I may, what Justice Glasgow declared in that matter, the matter was not determined under Section 5 of the Constitution. In other words, everyone agrees that, including the Attorney General, everyone agrees that flogging is inhumane punishment.
That's the Section 5 of the Constitution, yes.
Exactly. What, however, the Attorney General office was saying is that it is for the Parliament to change the law. that the court cannot declare the punishment of flogging to be in violation of Section 5 of the Constitution, because Section 5 specifically says that no law shall be declared to be in contravention of this section if it provides for a punishment that you had from the colonial days. But what Justice Glasgow decided, and correctly so in my view, was that all that was saved was a challenge on the ground that the punishment is inhumane. It did not save a challenge on the ground that it is discriminatory.
And I think that's where you had pivoted the argument. You pivoted the argument to Section 13, and he agreed with us. Because I think by you going to the discrimination part, well, you pick it up from there.
Yes, because since 1824, as we said, flogging has been abolished for women.
Yes.
Since 1824, that's what, 190 years? But it remains lawful for men.
That's 200 years.
Almost 200.
Yes.
And Justice Glasgow agreed that, I mean, they are one of the core values of our society now is gender equality. You cannot achieve gender equality by flogging women. Nobody will agree to that. Even the Attorney General said so. You cannot achieve it in that way. The only way you can achieve it is to provide the protection that women have had for 190 years to now extend it to men. That is how you achieve that equality.
But you know, when I read that decision, you know, you always hear people say it, but it came out in full relief in this decision. The central importance of crafting your case and the importance of presenting your case in novel ways that would allow justices to see another way around a major problem. You know, it is said that he who crafts the argument in many respects wins the case, because of the centrality of presenting that case. And I think that this case speaks to that question, that based on the Constitution, you say, all right, we may not get through on the ground of cruel and inhuman treatment. But what about, how are we going to deal with this issue of discrimination? And it was an argument that was well presented, and it allowed, based on, after that panoramic view of this issue which Justice Glasgow did, it allowed him to see that and to say, well, look, here's a road that seems to be open for me. But had that point not been taken, that's what I'm trying to say, you probably would have felt locked in on the savings clause point.
Yes,
and
I think so as well. That's right. That you're quite right. And in fact, in arguments in the court, before the judge reserved his decision, and what was it, 6 months, about 8 months later, when we went to the court, he was going along. He said to Ruggles, "Well, I can't see it because we have the savings clause." And then when Ruggles dropped the argument about discrimination, I remember the judge sitting back. I mean, he visually realized this was where the rubber met the road. And it's an argument. I remember, Joe, you saying, when, you know, while we were preparing the arguments, that there is no way around the discriminatory, the Section 13 argument. But I think if you had not pivoted to Section 13, the court would have been stuck. And for all the agreement about inhumaneness, and even with the other parts of the other arguments that we took, this portal through discrimination is what I think allowed the judge to rule in favor of striking down flogging.
But there's another point.
There was also someone has posted here that Section 13 in subsection 4 allows for privilege or advantage to be afforded. And that was one of the arguments that, in fact, was being taken. However, that privilege or advantage, it goes on to say, must be justified in a democratic society.
Yes.
And that was the point, that in a democratic society in 2024, you cannot justify flogging, protecting women from flogging, but not extending the same protection to men. In 2024, you cannot justify it. You cannot justify it the same way. You cannot justify a man and a woman doing the same work and you're paying them different salaries. You cannot justify it. There are so many things that you cannot justify. You cannot justify now on the basis of gender. And the court, in my view, correctly found that that was one of them in 2024. So that's why, yes, there can be exceptions. Yes, there can be differences in treatment, but it must be justified in a democratic society. So, for example, one argument was that, well, men are naturally stronger than women. But that argument really doesn't go anywhere in the world today.
Because it means men must take more blows.
Yes.
That's right. That's right.
And it means that women cannot do, if you take that, you can use that to create a barrier for women becoming engineers, becoming pilots, you can use all kinds of
firefighters
justification to prevent it.
Jerry would well tell you, we were living in the United States at a time when there was this big fight over whether women can become firefighters and police officers and so on, particularly firefighters in the 80s.
Especially firefighters, yes. Yeah.
But I think I'm not so sure how much more time we're going to spend on this, but I think that the elephant in the room is the whole issue of the savings clause. But beyond that is the ways in which the Caribbean jurisprudence is going in different directions, because the Privy Council has held on to the view that essentially the savings clause, unless the Parliament moves, nothing can be done. And that is the most recent case that I can think about is the Chandler's case. But the CCJ is going in a completely different direction, and the CCJ is saying, no, we can strike this down, or we can step away from it if it is violative of the fundamental rights and freedoms. But so now you have what we essentially have. We have Belize, Guyana, Barbados, Dominica,
St. Lucia,
and St. Lucia saying this is the way we can go, and the other Caribbean territories that still loiter on the premises of the colonial authorities going in a different way. So it is something that hopefully we can resolve soon, with us having a jurisprudence that caters to the rights and freedoms which are articulated in our constitutions, and have us move away from this notion that.
So I think this is yes. The punishment of flogging is so rooted in slavery that it's a good point to use, Jerry, to pivot to the issue of reparations.
Yes, sir.
It's very interesting, the position of the British Prime Minister. And I will just say it shows so Keir Starmer was, I don't know if you are aware of that, Jomo and Jerry, I'm sure you are aware, was one of the lawyers who, together with Ed Fitzgerald, carried a lot of the arguments.
Tremendous. It's what a contradiction.
Yeah, of course. Yes, before the Privy Council on many of these matters.
But that's 40 years ago.
And so, you know.
The Daniel Ortega syndrome.
Okay, it's the issue of I guess there's a saying, life is a stage and you play different roles. So I guess that is partly what is coming out there. So a lot of progress has been made since the 1970s on the issue of reparations. It is now accepted as a mainstream idea, mainstream agenda item. At one time, it was seen as madness. In fact, we had Bert Samuels on this program before, and he was speaking of the early 70s when he and others, in a sense, began intense advocacy on that matter. They were seen as basically outliers, as young radicals who, not living in the real world, don't want to go back that far and so. But now it is accepted, but there is that pushback from the British government, interestingly, both from the ruling party and the opposition party. I don't know, Jomo, if you want to just take up from there, being a former chairman of the Civil Reparations.
I didn't hear you for a few seconds. I did not hear you for a few seconds. The internet went down. The last thing I heard was when you said Bert Samuels.
Yes, I
talking
said
about 1970. But I think I have the gist of it. And yes, in a sense, what a difference a decade has made. Because I remember being part of the St. Vincent delegation to the CARICOM meeting in 2013 in Trinidad, heads of government meeting, in which the issue of reparations was placed on the agenda. And I remember telling Prime Minister Gonzalez at the time, if we can get half of the CARICOM members to support the idea, it would be a major achievement. And lo and behold, we went to that CARICOM meeting, and the decision for CARICOM to pursue reparations was a unanimous decision. And as someone who had sat on the St. Vincent and the Grenadines Reparations Committee, which was formed by the government in 2013, it's really an important development for the tremendous amount of progress that has been made. Because when I got back to St. Vincent in 2004, having spent over 2 decades in the United States, we formed the St. Vincent and the Grenadines Reparations Movement, but we were still groping on the side, trying to get into schools, trying to get into church organizations and so on. Once the government allowed what became part of a government policy, and there was an official reparations committee, we had greater opening to go to more places and talk to more people. And there was a way in which the Caribbean Reparations Committee had done like a monitor to check how many hits the issue of Caribbean reparations got. And in the period, in the year after the announcement in July of 2013, there were 100,000 where people started talking about reparations afresh. This is a significant development. I don't know if people remember, but in the 2016, is 2016 or 2020? I think in the 2016, well, for one thing, in 2014, Ta-Nehisi Coates had wrote that classic piece on the case for reparations in the United States, which helped to catapult the issue on. But by 2016 presidential elections, in the run-up to that election, you may recall 16 of the 19 Democratic contenders pledged in one form or another a commitment to looking at reparations. So a lot has happened in that very short period. So in many respects, the Caribbean governments have to be given some credit for bringing the issue front and center, because as our colleague Bert Samuels said, in the 70s, it was the Rastafarians who talk about reparations and repatriations and so on. But that was more like a fringe issue. I mean, in the United States, the Queen's Mother Mourn and Cobra and those organizations were doing that work. And by 2001, we had this reparations case, of which I have the honor of being part of, the Adria Farmer versus Fleet Boston and many of these New York Life and so on and so forth. But certainly the issue is now fully on the agenda, and this is why we have this kind of pushback. You may recall in 2015 when British Prime Minister Dave Cameron came to the Caribbean, he talked about, he said, no, we're not going to look backwards, we're going to look forward. But if you're willing to, we can give you some money to build a prison, Jamaica, and we can take some of your prisoners who are now in prison in the UK. You can build a prison and have them there in Jamaica. But there's something that Keir Starmer says, which is not true. He says, we do not pay reparations. Well, that's not true, because recently, a few years ago, they were compelled to pay reparations to some of the survivors of the Mau Mau massacre.
Right.
That was Lede, the British firm, had brought this claim, and they end up paying. So it's not true that they don't pay reparations. And what needs to be done is for greater effort to ensure that they pay. Just one last point, because I want Jerry to come in. A lot of people may not know this, but in 1833, the British government borrowed 20 million pounds to pay off the enslavers. And a lot of times people like to talk about, oh, slavery is in the past, you need to forget it, pull yourselves up by the bootstrap. What people don't know is that the British government only finished paying that loan from 1833 in 2015. So 9 years ago, they finished paying that $20 million loan. And that loan was in today's dollars about $20 billion dollars. And interestingly, in 1833, 20 million pounds, because I'm saying dollars, 20 million pounds constituted about 40% of the GDP of Britain, and which those people, absentee landlords who were big people in Britain, used to fuel the further development in England, particularly pushing forward, catapulting the Industrial Revolution and so on and so forth. So I just want to put those points out there.
Right. Jerry, before you come in, I just want to recognize the sponsors of this program: Jail Professional Solutions, Inc., Gem FM carrying this program out of Canada, and Grenada Technical and Allied Workers Union.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Yes, and Jomo, just to make the point that some observers have made the point that you had the obscene situation of descendants of slaves in Britain, in particular those who came from the Caribbean, part of the Windrush generation, and so on. Actually, by paying taxes, they were contributing to pay off that debt to those who enslaved their ancestors. So I just wanted to point out that Bud Samuels had an article in the Gleaner, and I was just looking for it there, and he was commenting on the statement by the new leader of the Conservative Party that a descendant from Nigeria, that they don't pay, that Britain will not be paying reparations. And he said, recall when Cameron, that's who he spoke about, the former British Prime Minister, came here in 2015, being Jamaica, he did, like Badenoch, that's the new leader of the Conservative Party, read the very same conservative script, arguing that we should not pay into the past, the conservative PM conveniently forgot that he had traveled to Jerusalem in March 2014, the previous year, where he laid a wreath at the ceremony in the Hall of Remembrance in honor of 6 million Jews who perished in the Holocaust. The truth is that Cameron's first cousin, 6 times removed, Mr. Duff, who was the son of one of Cameron's great-granduncles, the second Earl of Fife, was awarded £4,101, equivalent to more than $3 million today, to compensate him for the 202 slaves he forfeited in the Grand Sugar Estate in Jamaica. It is said that Badenoch, a black woman, has aligned herself with the heads of her enslavers and is now a powerful British leader on the wrong side of history, giving support to those who want us to forget and move on. That was Bert Samuels, who appeared in this program twice, in fact, once, speaking of reparations. Jerry.
Yeah. Of course, Jomo, you would know that I have, by virtue of being in the same circles as yourself in New York through the 80s and 90s, that the issue of reparations was very much front and center, and the position that we took then made us seem like outliers. So you coming to St. Vincent and being at the center of the movement here, that is for the peoples of the Atlantic world, in the United Kingdom, the United States, the Caribbean, to be repaid for their loss is, it's something of an earth move. It's a earth move. It's radical that it has now gone mainstream. But my view is that that's the problem. In other words, we are attempting, if you look at all of the movements that the Atlantic Africans have struggled for, emancipation, voters' rights, these have all come with the involvement of some long tears and blood and sweat. I get the sense that the reparations argument has it's like a sitting, a teaching, instead of a sitting. You know, it is. I get the sense that we have not leveraged, as we had in the previous movements, the tremendous strengths that we had to take us forward. Because outside of the moral argument, the moral appeal, what other tools do we have? You know, with the fight for the vote, adult suffrage, for the fight for freedom. I mean, I could see where we took steps that forced the folks on the other side to recognize our seriousness. Does this not mean that in the struggle for reparations calls for direct action? The kind of political strategy that would have given us the success we had before. Isn't it time, because we have now gone into the schools, because there's such a serious level of awareness among our people, because the moral chord, the tone has been struck, it is now undeniable that California, state of California, has recognized and enshrined in law that it is going to pay reparations. Hasn't the time come for direct action? And by that I mean preventing, in a practical sense, the landing of British Airways on the tarmacs of our airports in the Caribbean. Because you see, what do we have other than moral suasion with reparations? What else do we have? I don't know. I look at the other struggles along the historical grid of our struggle and how we are able to achieve them. And I think the reparations call just maybe the most passive of our, at least in our approach. You know, we have to move the lever. Forget the United States. I don't see the Congress, maybe some state legislatures, but with the Labour Party in UK, as it is now, with this leader they have now, and the Conservatives, do we not move to stop traffic, Jomo? Don't you think it's time for this strategy? I mean, Laura and the other folks who, it is clear that they are people of conscience coming from the British upper class, and they recognize the inhumanity of their governments in terms of a reckoning with what was handed, the treatment that was handed down to us. But really, I see the need coming soon, Jomo, to press the point. The appeals in the decent appeals in the legislature, the letters, the meetings, the courthouses, I don't think those are the avenues by which we would achieve reparations. At least I think we must use some other things in our toolkit of resistance, which we know how to do.
Well, I think the toolkit, we have to utilize the entire box. I am not as pessimistic as you are, Jerry. I think that there has been significant movements. What we have seen is as because of that fill-up in the reparations movement in the United States, in the Caribbean, and even in Europe. For example, the Portuguese prime minister at one time said that he was prepared to have a conversation about reparations. We have seen that many big companies in the United States and universities have given back something which they had kept for themselves. Georgetown University, Brown University, Harvard University, Aetna, Insurance, New York Life, all of them have acknowledged and have given back something in terms of, they want to set the parameters around which they respond to this. Lloyd's of London has done. But remember, 12 years ago, none of that was taking place. In fact, if we go back to 2001, when we brought the D.H. Farmer case against Fleet Boston, New York Life, and Aetna, and so on, some of those, I remember New York Life had responded with, I think, put up $5 million. Was it $1 million or $5 million to educate African-American students? So there's some movement. And sometimes, you know, it is said, and Frederick Douglass said it well, power concedes nothing without a demand. Never did, never will. In fact, the Grenadian cultural artist, thinker, Audre Lorde says, we can't use the master's tools to dismantle the master's house. So we have to find creative ways to do what we're doing. In other words, we can't abandon any form of struggle, but we have to find other ways. And I think that we are making some progress. I agree with Dr. Hilary Beckles when he says that the 21st century is going to be the century for reparatory justice. I think there are going to be some zigzags. We're going to go backwards, we're going to go forwards. But I think on this question, there's going to be some serious work. You may be surprised to hear me say this, but I think one of the ways in which we can make more advance, well, I believe we may get a big push if we can move the United States along on the issue of reparations. And you may be surprised to hear me say this, but I think one of the biggest ways for us to get reparations in the US and have a snowballing effect across the former colonial world is for the monopoly which the Democratic Party has on the black vote. That monopoly must be broken. And if they can no longer see that African-American bloc as a solidified bloc that they can take for granted, then I think if both the Democratic and Republican parties are contending for that vote, I think more and more they would begin to think through ways in which they're going to find themselves attractive to the African-American constituency, and reparations may be one of those.
Because the caucuses, all the caucuses at the state level and the federal level, all of the caucuses in black caucuses, the POC caucuses, the people of color caucuses, almost all of them, there's a universal recognition that, reparations, there's no question about the issue of reparations. Perhaps you're right, I am perhaps impatient. And because at least here in the Caribbean, just seeing what our incredible needs are, Jomo. And this last case of flogging, just to think that how little we have moved as a people around the idea of challenge. But even as I say this, it seemed to me that the center of the reparative justice movement has moved to the Caribbean. As I hear our friends in the United States speak of reparations, they often point to the work of Caribbean reparative.
Yes, the 10-point program from the Caribbean.
The 10-point program as actually a blueprint.
Yes.
I'm hopeful, Jomo. I am entirely hopeful. But so I just hope we are not abandoning everything that's in the toolkit.
So Jomo, you actually say that because that was one of the issues that was introduced, namely recent events in the US. Yeah. So you actually say that in terms of those events and the process across there, it could actually turn out, starting maybe not now, but going into the future, to be a fillip for the movement.
Indeed. Look, I don't think.
Jomo, are you really saying that based on what happened on Monday?
Yes.
I mean, this is a hell of an idea, Jomo.
Listen to this. Listen to this, Jerry.
Go ahead.
The first it was only in 1935 that black people started voting Democratic in mass.
Yes.
1935.
Yes.
So that's less than a century ago. Hitherto, black people voted, particularly around Lincoln's effort, Emancipation Proclamation, and so on, in 1863, 1864. Yes. But then you had the Jacksonian counter-revolution by the 1870s, 1878, 1879, which catapulted to the Plessy versus Ferguson, separate but equal. So you had that, and then by the 1930s, particularly after the emergence of FDR,
and Plessy versus Ferguson was a case, because just for the viewers, was a case in the US.
Yes, I'm sorry. Yes,
cases. Yes, basically, tell us more.
Well, Plessy Ferguson was this case where that went all the way up to the Privy Council, and the Supreme Court. It was up to the Supreme Court. Sorry, and the argument was that you are separate, but you are equal. But the thing was, it was a case that came out of Louisiana, where there's this Plessy was this black person who tried to pass for white.
Was he black? He was right. He was right. He was a passer.
Black person who tried to pass for white, but he was high colored. And the authorities says, no, you have to, because back in those days, I think that was 1898, black people rode in the car, the horse, the donkey, everybody else. And the Supreme Court said, yeah, nothing is problem with that. You have separate quarters for blacks, you have separate quarters for whites. And that went all the way until 1954 with Brown versus the Board of Ed, where the Supreme Court says separate but equal is inherently unequal, and consequently they overturn that. But the point I'm making fundamentally is that black people were not always democratic. And in the last election, 92% of all black women voted Democratic and 80% of all black men voted Democratic. Whereas 55% of Hispanic women voted Democratic, and I think 40% of Hispanic men voted Republican. 20% of African American men this time voted Republican. And some of us, if we look at it on the surface, may think that that's a bad thing. But if we take the long view, and I suggest we take the long view, that I believe there's great promise in us, because black people is the only bloc that is so monolithic in its support for the Democratic Party. And the Democratic Party, in fact, you may recall, you may remember in May of 2020, Joe Biden campaigning in South Carolina said, if you are thinking whether to vote Democratic, you have to think whether you are really black, because they had that ironclad support among African Americans. I do believe that if we take the long view, if our people begin to say, look, we are not going to give you our vote on the platter like every other constituency do, there's going to be greater push to get us to support. And that is going to redound in different parties of the two major parties, or whoever else may emerge in the future, having to contend for a vote. And one of the issues that we can push for is reparations. Because without that, in 2016, all of these people saying, yes, let's consider some form of reparations. I'm sorry.
Yeah, I would say in other words, black people should move to the stage where they are not taken for granted.
Precisely.
You know, this is something that we had been talking about for as long as I had lived in America, all those 40 plus years. This idea. I remember when Jesse ran in, was it 84? He first ran in
84 and 88.
And then in 88. That was always the issue. The Democratic Party taking the black vote for granted. And, you know, Jomo, the idea that the 2024 elections in the United States are an opportunity for maybe since over the last 100 years for the black community to leverage its political power. I didn't see that. I didn't see that piece. That's a hell of an opportunity, because there's considerable awareness, I think, in the black community for the power of that vote.
Absolutely.
Although the Obamas were trying to, I think they did not work. Their arguments were not very well. That's a class issue I'm not going to go into. But I think this so it would require then this who the black churches, the black union, or the unions, the churches, this black community. Somebody's got to preach this religion, Jomo. This is quite an interesting idea. I don't know if there are any parallels in history where the black vote, except likely in 1864, 63, 64. I can't think of any other period when the black vote could potentially hold the kind of power that you're articulating now, and to leverage it in this case for reparations. Can you think of any other period?
I can't think of any, but what the evidence, even in the last election, shows that the price that the Democrats paid by sponsoring a genocide in Gaza, that they lost in Michigan, for example, in Dearborn, Michigan, where Biden won 69% of the votes, of the Arab American votes, and went on to win that state. In this election, Harris got 31%, and Jill Stein, the third party candidate, got 20% of the Arab American vote. The other
Tlaib, I think Rashida Tlaib got a landslide among the Arab Americans.
Yes, indeed.
Yes.
And just one other quick point on this, just to show that there's a price to pay if you don't allow people to take you for granted. On this same question of genocide in Gaza, a lot of young people came out and were protesting on the universities, and the democratic state crushed them.
Yes.
And you saw a significant fall off in youth vote. A lot of them did not vote. You have to remember, Harris got 14 million votes less than Biden got in 2020.
Yes. I think I
don't want us to stay on the U.S. part, because I want to come back to the Caribbean to say what I think needs to be done.
Yes,
but I think if we can get a breach there in the U.S., it would have a big, because of what the colossus that the U.S. is, it would have a big play, not only the Caribbean, but across the world.
Right. I was saying we don't have much time, but an important tool in the kit, I think, Jomo, is social media, the internet. And if that is used in a really organized way, I think it will make a tremendous difference. But I'm talking about having an organization now dedicated to that and utilizing all our creativity on that issue in a focused manner. I think it will be amazing. In other words, we have the political leaders, and so they need to build an organization. But I just want to take a Facebook user. What would be a fair and realistic estimate of reparations for Grenada, considering its historical experiences with colonialism and slavery? And is it possible to negotiate a deal between the IMF and the World Bank to cancel or restructure Grenada's debt as a form of reparative justice? That's a question. I don't know if you have much time.
I think Jomo is better suited to answer this, speaking of the 10-point plan and one of the points that we've addressed. Yes.
Right. Well, I was hoping you would answer it, since it talks about Grenada. But yeah.
No, it's all right.
I don't know whether we can get the World Bank or the IMF to deal with those. But one of the problems that has happened, Eric Williams said that when the British were leaving the Caribbean, actually, he said the British treated the Caribbean like an orange, in which they suck all of the juice. And when they were departing, giving away independence and departing, their only concern was that they did not slip and fall. So the way in which we deal with this question, I think it goes back to what you were saying, Layne, that we need organizing, we need leadership, we need mobilization. We need to bring younger people into this effort. And I think the social media part is I remember I went to a reparations conference in Antigua, and I was making the point to the Jamaican rep. I think it was Lisa, what's the lady, Lisa Hanna at the time. I was saying, is it possible for you to get Usain Bolt at one of his races, when he wins, to rip off his shirt? Remember how the black brother who used to play for Italy? Why only me when he scores? If we're gonna get Usain Bolt to rip off his shirt and say reparations now, those are the kind of things that I think that
Tommy Smith and John Carlos in 1968.
Right, Carlos. Those things are a fact. I don't know. In the same look, there was an analysis done in which it was said that the British owe Jamaica $21 trillion. The Indians have calculated that the British occupiers took about how much was it? I think it was $500 trillion out of India. All of these things can be quantified. Remember, in 1834, with the Emancipation Proclamation, they paid 20 million pounds. And a lot of us in our school, we heard that the British paid 20 million pounds. What we didn't know is that the apprenticeship period of 4 years gave an additional 27 million pounds to the enslavers. So not only did the British pay the 20 million pounds, but we end up paying another 27 million pounds for our freedom. And that's what the apprenticeship was until 1838. So the quantification can be done. One quick piece, that between slavery was abolished. The British conquered St. Vincent in 1797. And so we had the shortest period of organized slavery from 1897 till 1834. But and I found this out only 2 years ago, between 1808 and 1815, St. Vincent was the second largest producer of sugar in the entire Caribbean. To tell you the depth of the exploitation of it, because St. Vincent is a little place, right? It's just 18 miles by 13 miles. So we can quantify it. The records are there, and the Caribbean Reparations Commission and the Center for Reparatory Research, we have all that information. We have the slavers, we have who gained, we have how much money they gained. We have the ships to talk about who took the sugar out and whatever else they took out. We have intellectual capacity. We know that we can do this for ourselves. In fact, the battle group, you may recall, where the Jamaican brother sat on, did a lot of work to show how much these colonial authorities owe Caribbean former enslaved peoples and countries. Because the big problem we have is that precisely because we were left so unprepared for independence, the Caribbean are some of the most indebted countries in the world. Because we were left in shambles, and many of the governments just went ahead and borrowed money to try to bring us up to speed, and we are still in the deep hole. So the point about whether we can get money to cancel debts and so on and so forth is a very important, and that's one of the 10-point plan.
Okay, we unfortunately we'll have to end soon. But before we do so, I just want to once again recognize the sponsors of this program: Gel Professional Solutions, Gel FM, carrying this program on FM radio out of Canada, and Grenada Technical and Allied Workers Union.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Yes, so before I invite closing comments, I just want to say something of my own in terms of in closing, that the reparations movement, I think, to be really successful going forward, to take advantage of the fertile ground that has been created those who have really given a lot, dedicated their lives, the Rastas, young black advocates who at one time may have been seen as crazy, our current leaders, to really build on that fertile ground. We have to organize this as a serious movement. And there are lots of areas. I spoke about the internet and the other areas. So just to dovetail on the flogging case, what it shows also is that there is room for the law, there's room for creative approaches, creative arguments, and there's absolutely no doubt that we have people in the Caribbean who are capable of framing, conceptualizing and framing arguments that could basically take the issue of reparations to international courts as another point of leverage to seek reparations. And I think that's really where the future is, and I'm very hopeful that there are young people who will take up this banner and take up the banner of bringing about transformation in the Caribbean to our legal system and to our struggles. I know ask you started with Jomo for final questions.
All right, just quickly, because I think I talked too much in this this segment, but they're just two points, huh? On the issue of reparations, I totally agree with you that I think we need no blood, and we need the younger generation to like they say, we got to make it sexy. We got to make it attractive to young people, to pull them into this, make it their mountain. Fidel used to talk about every generation has to find a mountain to climb. We need to make this their mountain. Let them see it as something that they can do. Because, again, I go back to Audre Lorde about using the master's tools to dismantle the master's house. In many respects, not only are big, powerful governments pulling our governments to ensure that they don't go all the way, but the politicians themselves, I don't think, have that necessary drive, that necessary push to do this in the ways in which a younger generation. These kind of activities are essentially revolutionary activities, and revolutionary activities are a function of youth. Youth are the people who do it. We become more status quo the older we become. So that's just one point. On the issue of the flogging, I just want to go back to Charlie Houston, who was one of the founders of Howard University Law School. Charlie Houston said that he used to tell his students when the school was formed that you're coming into these halls and you have a choice. You can either become an agent for social change, or you can be a parasite on society. What the case that you all did on flogging shows that you find creative ways to bring change, serious, important change. And I think that's positive. And I'm hoping that we can begin to train other people who can pick that up. All of these islands need to have a Center for Law and Social Justice to push these things forward.
It's
Jerry?
thank you, Joe and Brother Jomo. It's always nice to sit down and reason with you all. There's I think a lot of fight still left in all of us, in spite of our advanced youth. I think that we have some temerity still, and we will join the fight with that.
Like that, Jerry. I'll use that advanced youth.
Well, yes, sure. I think we can do. Joe, we have, as you know, Joe, we've identified a number of other laws that we hope in their extinguishing will be a catalyst to lead a new movement of awareness in our people, that, as Malcolm used to say, we are the change, we are the agents of change, I'm paraphrasing, that we are looking for. We are the leaders we are looking for. that younger generation, I think we have to make them know that they can be, and by necessity, if they want to get themselves into that other lane of personal advancement, of being able to enjoy the fruits of life that everyone else has, that they too, it's almost as though young people have to make a contribution to their own struggle, and perhaps to convince them of their agency is a way we can take the reparations fight forward. I think I see the flogging issue as a platform for us to climb on to get to all these changes.
Yes.
Right.
So, Brother Jomo, thank you for appearing. Jerry, thank you for appearing.
Thank you
Both
for
of you,
having me on.
thank you for your work in these areas. You know, you as lawyers, you stand up for people, you take cases that others may not be able to take, you stay in fights that others may get tired of, and as you said, I think you are carrying out the mandate of the law professor you spoke about. You are both agents of social change. Thank you to the viewers, thank you to everyone. Until next week.
Thank you. Good night.